So you would, based on your experience, you would say that the yellow seal represents...
The original seal.
The sealing on November 18, 2003.
Yes.
And then you see at least one seal from later in November of 2003. Is that correct?
Yes.
So that implies or suggests to you, based on your training and experience, that somebody broke the yellow seal, opened the briefcase...
Yes.
And then resealed it.
Resealed it.
And how many other, or were there any others between then?
Yes, there's one other, 11404.
Okay, so on the 14th of January 2004, somebody else apparently did the same thing, which was at least open the briefcase and then reseal it.
Yes.
And you don't know what any of those people did with the contents of the briefcase during those two incidents between the original seizure and January 20th?
No.
Welcome back. Science work or guesswork? Yes, I'm imitating Howard Weitzman. Defense attorney Robert Sanger puts fingerprint analyst Lisa Hemman under his microscope. Here's what she told jurors during cross-examination according to the courtroom transcripts.
So fingerprint identification is really subjective. Is that correct?
Yes.
In other words, it's up to somebody who has training or, in other words, or whatever their background is, to look at the latent and look at the rolled print and make a subjective determination that they believe that it's the same person. Is that right?
Yes, with training.
And we have indicated with a couple of examples, and I won't go into any more particular ones with you right now, but there have been a number of other notable misidentifications of prints in recent years, have there not?
Yes.
The materials in the briefcase are lawful to possess by an adult in California. Is that correct?
I believe so, yes.
Most of it's commercially available in one sense or another.
In one sense or another, I guess, yeah.
In other words, some of you can buy at a newsstand, others you might have to buy at a specialty store of some sort, but they're available, right?
Yes.
All right, all you armchair Johnny Cochrans out there, make a mental note. Subjective. Subjective is the watchword on that testimony. Here's what happened on redirect examination.
I'd like to show you Penal Code Section 313.1 and ask you to read it to yourself. Subparagraph A.
I'm sorry, is this to refresh recollection? If it's not, it's improper.
It's improper to read in court?
That's such a good straight line, there's got to be an answer, but I don't have one, Your Honor. It's not proper to have the witness read something unless there's a foundation laid refreshing recollection. She's being asked to read a law book.
I never heard that objection.
Have you read it?
Sort of.
Object, irrelevant. Have you read it? It's got to be relevant to something. Refreshing recollection.
It will be, Your Honor, and if it's not, the court won't let me ask the question, I'm certain.
The objection is overruled.
Okay.
Finished reading?
Yes.
Okay. Mr. Sanger elicited from you that the opinion possessing the kind of material that you found in the briefcase is generally lawful. You gave him the opinion that you thought it was.
Lawful to own by an adult.
If that material were shown to a minor?
I believe...
Objection, Your Honor. Calls for a legal conclusion.
It's rebuttal to your question, counsel.
It would be illegal.
You may answer.
It would be illegal to the minor.
And that's Penal Code Section...
313.1A.